hotter than today. Yeah. Andy. Thank you, sir.
Supreme Court is now
Good morning, please be seated. On record, the State of New Jersey versus Paul Caneiro. It's an indictment 19-02-0283. Counsel for the record.
Good morning, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good morning, Judge Chris Decker, Assistant Monmouth County Prosecutor for the state.
Morning.
Morning, Your Honor. Still an attorney on behalf of Mr. Caneiro, who's present in the jury box.
Good morning, Judge Andy Murray, also for Mr. Carroll.
Morning. All right. So prior to today's date, I had the opportunity to receive the pre-sentence report. There were some slight modifications due to the change in date for the sentencing from May the 12th to May 19th. There's also some other minor modifications that were made. I've also received from the defense, I did not receive a sentencing memo. However, what I did receive was character letters that I have read in their entirety, and they will be incorporated in the pre-sentence report for purposes of the sentencing, because that was what was requested. I also received from the state a sentencing memo that I have read and contemplated. I've also received a few letters from Jennifer Caneiro's family that I have reviewed, and I also received this morning some information from a friend of Keith, Darren Altman, and also an impact letter from Corey Caneiro. So I have reviewed all of those documents. I'm going to ask and remind everyone, as I've said from day one, that I do not need for anyone to reiterate what they've already said. I promise you with all of my heart that I've read everything more than once to be prepared here for today. But with that being said, I will now ask the state to move the sentence.
Thank you, Judge. This defendant appears before the court for sentencing. At this time, Your Honor, I would note that some of the victim's family and friends are here, and when it's appropriate, Your Honor, if we could, before the state speaks, if I could have Jennifer's sister and mom speak. Also, I would note that Darren Altman is here, a friend of the family who would also like to speak.
Okay, would you want them to speak first and then for you to speak?
If that's okay with the court, Judge.
Okay, so for the individuals that are going to come up to speak, we have a podium right here to my right. I'm just going to ask for you to stand at that podium. I find it may be more comfortable for you to be able to have that so you can hold on to something. All I'm going to ask is that anything that you want to say, direct it towards me, not towards the defendant, towards me. You can say what you want to say, but I want you to direct it towards me. Does everybody understand that? Okay, great. Everyone's shaking their head yes. Ms. Wallace, you can indicate who is going to speak first.
Thank you, Judge. If we could have Darren Altman.
Okay. Draw the phone up. Sir, I'm going to ask you to state your full name for the record and spell your last name, please.
My name is Darren Altman, and my last name is A-L-T-M-A-N.
Okay, go ahead, sir.
For 24 years, almost 24 years, I worked for Keith Caneiro at Square One. He was more than just an employer. He was a person who believed in me when I needed it the most and gave me the opportunity to build the career that I have today. Meeting Keith was one of those crossroads in my life that changed everything. Over those many years, he became a true friend and a constant source of support to me and my family. His loss has left a void that is impossible to fill. I remember countless evenings with Keith and Jennifer, joined my wife and I for dinners. Those nights were filled with laughter, wonderful conversation, and in many cases, good food. Years later, when I was faced a challenging time being confined to a wheelchair after an accident, Keith and Jennifer were there to reassure me that they would be there for me and my family. They made it clear, whatever I needed, they would be there for us, and they always were. And it's hard to imagine how my life would have turned out had our paths not crossed. The impact of their kindness and support is something I will carry with me forever. It has left a mark on my life that I will always cherish. Your Honor, the loss of Keith, Jennifer, and their children is an immeasurable tragedy For this reason, I respectfully ask the court to consider the maximum sentence for Paul Caneiro. It would not only bring a measure of justice to the Caneiro family that was taken from us, but it would also be justice for the fortunate ones who need them. Thank you.
Thank you, sir. Appreciate it.
Judge, would it be possible to have Jennifer's mom and sister come up together?
Absolutely.
Sure, you guys can just stand right together.
The only thing that I ask is I'm going to ask both of you to state your full name for the record, but then whomever is going to speak first, if you can just say your name so that we know for the record who's speaking, okay?
I'm Bonnie Caritas.
Okay.
Vic Caritas. K-A-R-I-D-I-S.
Thank you.
My mom.
Okay, go ahead.
Good morning. Your Honor, members of the court, and all of you who have worked diligently to bring justice and closure to my family. I thank you for all you have done. I believe you will do what is right and remove this killer, this monster, from society for good. I am sorry for all of us who have had to sit through those weeks and hear those horrible, gruesome details. This is what life has been for me, my husband Velasquez, and daughter Bonnie, ever since Paul Caneiro slaughtered my beautiful family, murdering his own brother, my daughter, my grandchildren, Jesse and Sophia. He stole the source of joy and happiness in our lives and replaced it with bottomless sadness, sorrow, and grief. Sadly, my husband Velasquez is not here today. He died without knowing that justice was done for our family. During the trial, the defense attorney once said to a witness, "You don't know what you don't know." I would like to tell you what you do not know. Jennifer, my daughter, was a beautiful person. She was warm, vibrant, caring, wife, daughter, sister, friend, and most of all, a wonderful mother. She was not just loving, but accepting of everyone for who they were, which made her even more special. She loved each person in her life and brought out the best in all of us. Keith was a loving and devoted father, husband, son, and brother. He had a brilliant mind, and his success was only because of his incredibly hard work and doggedness. He was the son I never had, a true, loving son. A man who would be there to help anyone in need. Jennifer and Keith had the same birthday, and sadly now share the same day of passing. They loved each other. They each took the other's families into their lives and made it all bigger and better. Keith built that house to have a family in a beautiful place and to be a place for the families to gather. My grandson, Jesse. I wish I could have seen him grow up. He had a mind like his father's, so smart, deeply interested in history, the kindest heart, cared about everyone. Sophia, my beautiful granddaughter, so young, she loved to dance, sing, play with makeup. She put on makeup better than I did. She was joyful, spirited, and kind like her mother. Jesse would be graduating now and going to college in the fall. Sophia, high school. Lives stolen. There's not an hour in the day I do not think of them. And to think of them is to think about this terrible thing. How their last moments were terrifying, painful, and horrific. How each of them looked at their Uncle Paul as he killed them, killing them in front of each other like an animal. Most days it is hard to get out of bed because of these thoughts. Every birthday, anniversary, family, holiday is now filled with pain. Paul Caneiro's horrific and despicable actions have caused agony and grief beyond what anyone should endure. In an act of pure evil, he took the life of 4 innocent people, his own flesh and blood, out of greed and selfishness. He disgusts us. He represents the very worst of humanity. My family and I live with traumatic grief, depression, and anxiety, worsened only by him dragging us through these 7 years. He never once exhibited any remorse at all. Despite overwhelming evidence, he would not confess. He could have stopped this from dragging on, but no, he sits here today with his evil soul, still not admitting what he has done. He ripped the love and hope from our lives when he murdered Jennifer, Keith, Jesse, and Sophia. I hope it is impossible for him to ever, ever, ever be free. Our family he gruesomely murdered should be here in this world today, making beautiful memories. A son I could call for advice, a daughter who was a part of me, my grandchildren who I could hug forever and ever. 1,000 years would not be enough. Thank you, everyone.
Thank you very much.
Your Honor, my name is Bonnie Caritas, K-A-R-I-D-I-S.
Thank you.
And I am the sister of Jennifer Caritas Caneiro, the sister-in-law of Keith Caneiro, and the proud aunt of Jesse and Sophia Caneiro. Jesse was 11 years old, and Sophia just 8 at the time of their brutal murders and moments in life. An entire branch of our family was erased 7.5 years ago, 2 days before Thanksgiving. We are grateful to this court, to the prosecutors, law enforcement, the victims unit, witnesses, and the jury who worked tirelessly to bring this case to sentencing. But my father, Vlasis Caritas, he did not live to see this day. He passed away without knowing that there would be accountability for the loss of his family. I am here today so the court understands the staggering depth of not only what was taken from us, but who was taken. Jennifer was my younger sister, my best friend, my only sibling. I miss spending time with her, talking to her. She talked a lot. She really liked to talk. Laughing with her, our private jokes. Jennifer made people feel safe. She made people feel loved. She never let anyone feel alone. She was the heart of our family and a devoted mother who built her entire life around her children and anchored our family with love. I miss her every single day. Keith. Keith was the brother I never had. I could count on him for anything. I miss his advice and talking to him for hours on end. I greatly admired him. He was intelligent, driven, witty, generous, and deeply principled. He built a life of success and integrity, but more importantly, he lifted everyone around him. He adored his children, and he was raising them to be strong, kind, human beings. He was loyal to his family, committed to providing for them, and endlessly supportive of the ones he loved. Keith included and supported his older brother Paul, but Paul became consumed by jealousy, jealous of Keith's life, his success, and the man that he was. Paul's small mind, warped by jealousy and greed, turned into deliberate, calculating, murderous deeds. But Paul did not just take Keith and his family's lives. He tried to steal the legacy of a man whose character, compassion, and integrity he could never, ever come close to being. In his violent acts, he attempted to erase everything Keith built as a father, as a husband, as a friend, and as a human being. But Paul will never succeed at that, never. Keith's legacy lives in every life he touched, and no act of cruelty can diminish the man he truly was. Jesse was a bright, curious, and thoughtful 11-year-old boy. He had a sharp mind, like his father, and a gentle heart. He took his role as Sophia's older brother, seriously, protecting her, guiding her, and standing by her side. Jesse was remarkably tech-savvy for an 11-year-old boy. I missed the way he would confidently explain which phone was better or why one iPad made more sense than the other. He loved sharing what he knew, and I relied on his little lessons more than he ever knew. Losing his voice, his curiosity, and his guidance is a loss I feel every single day. Jesse had a whole future ahead of him. Dreams he was beginning to form, talents he was just discovering. It is devastating to know that a child so full of potential and goodness will never get the chance to grow into the man he was meant to be. Sophia was pure light. She was joyful, playful, and full of life, in a way that could brighten any room. She loved to sing, dance, bake, and play. Her laughter was constant, her spirit contagious. She brought happiness wherever she went. I miss playing dolls with her, hearing her sing, watching her dance without a care in the world. She was at the beginning of everything, every dream, every milestone still ahead of her. I can only imagine the incredible young woman she would have become. I would give anything to just have one more moment playing hide and seek with Jesse and Sophia, to hear their laughter again, to see their smiles, to know they were safe. We are not just grieving who they were, we are grieving who they would have become. The sheer malice and betrayal behind this is unbearable. They were executed and tortured by someone who was family, Uncle Paul, someone driven purely by greed and money. A home is supposed to be a sanctuary. They welcomed him into their space, and he took their lives for material wealth. The calculation and selfishness required to look his own niece and nephew in the eyes and murder them, an entire family, is a level of evil that is not comprehensible. 8-year-old Sophia fought against a grown man after watching her family destroyed. This was not only murder, it was sustained cruelty. Since that day, our lives have been shattered. Every milestone they should have had is now a painful reminder of their absence. The Satan in this room stole decades of laughter, holidays, graduations, and weddings from all of us for temporary material wealth. There is a permanent agonizing void that is filled with pain, sorrow, and grief. While my family's voices were silenced, their lives and the value of their lives should never be diminished. There is no sentence that can bring my family back. And there really is no justice in my mind for these crimes. But for a crime rooted in greed and complete disregard for human life, there must be accountability, maximum accountability. Your Honor, I respectfully request that you impose maximum sentences allowed by law. The defendant must be removed from society. Thank you for listening to my family's voice.
Thank you both. Ms. Wallace.
Thank you, Your Honor. Your Honor, in the state sentencing memo, we laid out our analysis of the factors such as merger, the aggravating and mitigating factors, as well as the Yarborough guidelines. So I won't rehash every single argument that was made in our submissions. However, there are a few things I would like to highlight if the court would indulge me.
Okay.
In terms of aggravating factors 3 and 9, the defendant's conduct at 15 Willowbrook Road was nothing short of a massacre. Keith, Jennifer, Jesse, and Sophia should still be here today. What he did to that family, to those children, was unspeakable. It defies any type of humanity. This was not an accident. This was not a fit of passion type of a situation. His conduct was premeditated, it was calculated, and it was planned every step of the way. And the thing about it is that there were so many instances over that 9-hour period where the defendant could have made a different choice. Even after he murdered his brother, he could have just gotten in his car and left, just leave. But he chose murder over and over again. The state had the opportunity to read the character letters that were submitted on behalf of the defendant. And what's interesting about those letters, in addition to all of them sounding oddly similar, is that in each of those letters, the individuals indicate that they believe the defendant to be a responsible person. Responsible. One look at the evidence, the actual evidence, that the jury sat and listened to would indicate that the word responsible and Paul Caneiro don't belong on the same planet, let alone in the same sentence. This is a person who is living beyond his means, stealing from the victims, and then doctoring bank records to cover up his crimes. And when the gig was finally up, when Keith caught him for the second time, instead of manning up, instead of just facing the consequences of what he did, instead of being responsible, he thought it better to wipe a family of 4 off the face of the earth like it was nothing. That is not responsible. That is the epitome of selfishness, and that is a coward. Sneaking up on your family and ambushing them in the sanctity of their own home, where they should have been the safest. And I would note, Judge, that these were not strangers, though that would be bad enough. These were the defendant's own family members. I submit that if he is willing to do such unspeakable acts to his own family, there is no limit to his capacity for evil acts. In terms of aggravating factor 1, Your Honor, the state would emphasize both the terror and the pain that the defendant inflicted on the victims. As the court will recall, Keith was shot no less than 5 times, with one of those shots being a contact wound to the head. The defendant then invaded their home, and inside that home was Jennifer, a 45-year-old mom. Her husband had just been murdered outside. She was alone in the house, unarmed, the power was out, the generator was off, and there was an intruder inside her house. I would submit that is terrifying in and of itself. Now add to that the fact that Jennifer had her 2 babies in the house with her. Jennifer was hunted down, as were her children. As the court is aware, Sophia was stabbed multiple times, and she had defensive wounds, or wounds that were consistent with defensive wounds all over her body. That little 8-year-old, 45-pound girl fought for her life against a 200-pound grown man wielding a knife. I submit that the terror that he inflicted on the victims cannot be understated. As far as the physical pain, I'm not going to belabor all of the injuries. I think we've heard enough of them. The jury's heard them at trial. The court has heard them. The children were stabbed and then left to inhale smoke. That is a shameful thing to do to any human being, let alone your own family members, let alone 2 children. Your Honor, the state has submitted to the court a letter that was written by Corey Caneiro. I'm not going to read that letter, Judge, but I do want to just, in light of that, I think that the state would be remiss to forget the impact that the defendant's actions had on Corey and his family. Corey was also Keith's brother and his best friend. Corey lost his brother that day, his sister-in-law, his niece, and his nephew. And then to add insult to injury, the defendant accused Corey of being responsible for these atrocities. Obviously, the jurors recognized that for what it was. Corey misses his brother, his niece, his nephew, and his sister-in-law, as do his children and their cousins. Judge, based on what the jury convicted the defendant of, as Your Honor is clearly aware, the defendant is facing 4 mandatory sentences of life with no possibility for parole. That is obviously the highest sentence that can be received in the state of New Jersey. The state is respectfully requesting that the court run those sentences consecutively, pursuant to Yarborough. Keith, Jennifer, Jesse, and Sophia were a family, but they were also 4 unique individuals, and they deserved to live full lives. Keith and Jennifer should have been able to grow old together and watch their children grow. Jesse and Sophia should have had the opportunity to finish out their childhood years, their adolescent years. As the family indicated, all of the milestones stolen from them. Their middle school years that were ahead, 8th grade graduation, high school, proms, driver's licenses, first dates, etc. Those were some of the big ones, but there were smaller ones too, like the family's weekly movie nights that the 4 of them enjoyed together, family vacations, play dates that the children had with their friends and their cousins, Sophia's Ninja Warrior classes, and Jesse's lunch dates with his dad. Jesse was 11 years old when he was murdered, and Sophia was 8. Jesse would have been 18 years old today, and Sophia would have been 15. Their friends and their family miss them and are deeply wounded by their loss. They were a good family, and they should still be here today. But they are not defined by their last moments, Judge. And with that, I'd like to leave off with just a quick story of something I learned about Sophia. In speaking with the family, I learned that Sophia at her school had something called a buddy bench, and that was basically where children who felt lonely or needed a friend would sit on the bench, indicating for other children to come over to them. And what I learned was that Sophia was always the child that would go over to the other children and make them feel comfortable and welcome and be their friend. That is who she was, and that is her legacy. They were a good family, and they should still be here today. It has been 7.5 years, Your Honor, 7.5 long years that the family has waited, that their friends have waited for justice. And today is the defendant's day of reckoning, and the state would respectfully ask the court to sentence him accordingly. Thank you.
Thank you.
Judge, I'm just going to start off by acknowledging the tragedy here. It's not lost on the defense that 4 lives were tragically lost, and that, as I think the first gentleman indicated, the amount of loss and devastation is truly immeasurable. To the friends, to the family members, community members of the victims. And so there's nothing that I can say to mitigate that tragedy. But again, it's not lost on us. And with that said, Judge, my role here obviously is to speak on behalf of Mr. Caneiro. So with that, I would note, as the court indicated, there were letters submitted by the friends and family members of Mr. Caneiro. The purpose of those letters was just to demonstrate that Mr. Caneiro is supported in his support. However, as everyone knows, the jury made findings in this case, and based on those findings, the sentence in this case is mandatory. It's life without parole. And Mr. Caneiro is well aware of that. He's prepared to receive his sentence today. And I understand the state is arguing for consecutive life sentences versus concurrent life sentences. And the defense would only offer that it's essentially two different ways of saying that Mr. Caneiro is going to be spending the rest of his life in prison without the possibility of parole. So with that, Judge, the only other thing I'll add is I did advise Mr. Caneiro that the court will extend to him an opportunity to speak. And in response to that, Judge, Mr. Caneiro he maintains his innocence, and he has nothing further to add at this time. Thank you.
Mr. Caneiro, stand. I heard what your attorney said. In light of what you've just heard, is there anything that you want me to say before I close sentence?
No, Your Honor.
Sure?
Awesome.
Okay. The defendant was found guilty by a Monmouth County jury on February 13th, 2026 of 4 counts of first-degree murder, 2 counts of first-degree felony murder, 2 counts of second-degree aggravated arson, 1 count of second-degree possession of a handgun for an unlawful purpose, 1 count of third-degree possession of a knife for unlawful purpose, 1 count of fourth-degree unlawful possession of a knife, 1 count of second-degree theft, 1 count of second-degree misapplication of entrusted property, and 2 counts of third-degree hindering one's own apprehension after a 6-week trial. As a part of the verdict, the jury unanimously found defendant committed these 4 murders by his own hand, and also found 4 aggravating factors to mandate a sentence of life without parole for Keith and Jennifer's murders, and 3 aggravating factors for a sentence of life without parole for Jesse and Sophia's murders. To be clear, only 1 aggravating factor is necessary to sentence you to life without parole. For each of the 4 murders, the legal question left for this court will be whether these sentences should run concurrent or consecutive to each other. The court must also consider the sentence for the remaining counts that defendant was found guilty. I reviewed the pre-sentence report. I've incorporated the letter supplied by the on defendant's behalf. I've also incorporated the victim's family's written and oral statements made here in court today. I find the pre-sentence report adequate for sentencing purposes. Defendant is 59 years old, married, father of 2 adult daughters, both of whom testified at this trial. Defendant's wife did not testify. Defendant denies any substance abuse evaluation issues, indicating he drank 1 to 2 drinks per week prior to his arrest in 2018. He claims to have PTSD at the age of 33 while working as a consultant. He traveled for work and claims he observed many violent crimes. As for medical history, he reports 20-plus surgeries from 2012 to 2018 after being involved in a car accident. While he reports being permanently disabled since 2013, defendant reports to being in good physical health to his pre-sentence report investigator, and he also does not manifest any observable disabilities. Defendant was a partial owner of 2 businesses, Square One, where he had 10% ownership, and EcoStar, where he had 50% ownership. Despite those ownership interests and salary, because he was deemed permanently disabled, he was also receiving $2,300 a month in Social Security and $7,200 a month in Social Security disability, totaling $9,500 a month at the time of his arrest. He was also the homeowner with his wife of a home in Ocean Township that we heard about, which was later sold. While incarcerated for these murders, EcoStar was sold in 2020 and Square One was dissolved. Defendant reports he is one of 3 children, Keith, who the jury convicted defendant of murdering, and Corey, who defendant claims is an alcoholic with mental health issues, abusive, and a pathological liar. It should be noted, and it was mentioned again here today, a big part of defendant's defense included an allegation that law enforcement should have looked into Corey a little bit further for these murders. The jury outright rejected that argument, finding defendant guilty of all 15 counts in less than 5 hours. Defendant has no prior record. Defendant was charged with insurance fraud pursuant to a separate indictment, but the state will dismiss that charge today after the sentence is imposed here, and because defendant has no ability to pay if defendant was convicted and restitution was ordered. I have also reviewed the pre-sentence report for the victim's statements that were provided by Bonnie Caridius, who spoke about the ruthless, premeditated murder of Jennifer, Keith, Jesse, and Sophia due to greed, anger, and jealousy by the defendant. To you, I agree with you, and I'm very sorry for your loss. I will incorporate the following facts into the aggravating versus mitigating sentencing analysis. In this case, there was an avalanche of evidence pointing to defendant being a callous, heartless, brutal killer of his brother, his sister-in-law, and 2 innocent kids. It's not a tragedy. It's a flat-out killing of innocent people. Tragedy is a much different word. He clearly planned these killings in the hours prior to driving the 20 minutes to Keith and Jennifer's Colts Neck house. Defendant's actions were calculated, from turning off his own surveillance cameras, to choosing ammunition that would cause massive destruction, to loading the gun cartridges with bullet after bullet after bullet, while in his basement of his house, only to leave his house in darkness with an evil, merciless eye to assassinate and annihilate an entire family from this earth. Defendant's plan took shape during that 20-minute drive to include shutting off the power in the victim's home once he arrived. That action describes a premeditated, targeted act of violence designed to disable home security systems and power, to create vulnerability, and to ensure that the defendant had the advantage against his brother and his family. Once the defendant disabled the power, he deliberately and tactically waited outside for his brother to execute the attack. Defendant then shot his brother multiple times, including an execution-style shot to the head, a coup de grace shot, as Keith's immobile body laid face down on the ground. It is clear to this court the defendant acted with a depraved heart, showing no regard for human life, let alone his brother's life. After extinguishing his brother's life, defendant set his sights on his dead brother's innocent and unaware family. While defendant is the only one that could tell us the timeline of the massacre inside this home, it would appear defendant set his sights on Jennifer, Keith's wife. Unknowing what had happened outside, Jennifer left the bed that her and her husband were just in, due to hearing these gunshots that ended her husband's life, and went towards the front door to see what happened. It seems that while there was no power to Jennifer's house, there must have been some sort of lighting. Or, referring to Exhibit S-170 from the trial, the FLIR 1 Pro thermal camera in defendant's possession, depicting the heat sensor that would show heat coming off the bodies of Jennifer, Jesse, and Sophia, and that would just make you a tactical killer. I say this because when defendant entered Jennifer's home, he shot her in the head with precision. That did not occur without any form of light or other sensory device. The gunshot wound to Jennifer's head tracked front to back. Jesse, age 11, Sophia, age 8, nearby, must have heard the gunshot that wounded their mother, or the multiple gunshots that killed their father, or both, because both of them left their bedrooms, and that's when the defendant potentially shot at Jesse, according to the evidence. Defendant then grabbed a knife and stabbed both Jesse and Sophia multiple times. Kids, innocent kids, they hadn't even had a chance to start their lives yet. We heard just about in this courtroom about all the life they had left to live. You stole it. There is no way to know for sure when, but Jennifer was also stabbed multiple times in the chest, back, and abdomen, either before or after the defendant stabbed her kids to death. Defendant stabbed Jesse 7 times in the upper body and torso. Defendant's injuries was left breathing but severely disabled. Defendant stabbed Sophia repeatedly over her body well over 40 times, including defensive wounds. One stab wound went right through her face and another through her chest cavity. Sophia was also disabled and left for dead. Neither child, without parents to protect them, due to your unconscionable actions, could get any help, not even for each other. Again, defendant is the only living person who can recount exactly how these events unfolded. But the evidence reveals a chilling and calculated sequence. After carrying out these horrific acts, defendant went into the basement and deliberately set a slow-burning fire carefully designed to give himself enough time to return home and manufacture an alibi. This was not panic. This was not confusion. It was cold, deliberate malice. Defendant engineered that fire to destroy every trace of what he had done, to erase the evidence, to erase the victims, and to reduce even their remains to ashes. As thick smoke consumed the home over the next several hours, Sophia and Jesse suffered further agony through smoke inhalation, injuries that ultimately contributed to Sophia's death. Even in their final moments, the suffering continued because of your calculated actions. There's no softer or gentler way to describe what happened here. Defendant committed familicide. This was an annihilation of an entire family, a mass murder carried out by the very person who should have protected them most. And why? Because defendant carefully constructed lies, because defendant's carefully constructed lies were collapsing around him. The manipulation that defendant used to control those closest to him was no longer working. Exposure was inevitable. The mask was slipping. The truth was about to emerge. Defendant was driven by greed, jealousy, selfishness, and a ruthless desire to preserve himself at all costs. Defendant's selfishness did not end with the slaughter of Keith and his family. It continued as he drove home and deliberately set fire to his own home, recklessly placing his own family in danger of death. Even then, his purpose never changed. He wanted to destroy the bloody clothing, the physical evidence, and every item that could expose him as to the depraved killer he truly was. The irony is staggering. Defendant was willing to burn down his own home, the very place where his children should have felt safe, simply to protect his secrets and conceal his monstrous actions. He desperately wanted to preserve the false image he had created for himself, the caring husband, the good father, the victim of some terrible attack. But the evidence tears that lie apart, piece by piece. Defendant was never a victim. You were the cause of all of it. And the destruction did not stop there. The evidence shows he attempted to set one of his own vehicles on fire in another calculated effort to destroy incriminating evidence hidden inside. Every step he took was driven by deceit. Every action revealed another layer of manipulation, another desperate attempt to escape responsibility for the horror he created. The lies were relentless. The deception was constant. One of the many heartbreaking parts of this case was watching the devastation inflicted upon the defendant's own family in the aftermath. His actions left them displaced, homeless, and shattered, while his children tried to comfort the very man responsible for destroying their lives. There are few betrayals more profound than that. A father is placed on this earth to protect children, to protect his own children, to protect his niece and nephew, to shield them from harm, to sacrifice for them when necessary. You did the opposite. He sacrificed everything that belonged to them, their home, their security, their peace, and their future, all in a desperate attempt to save yourself from the consequences of your own evil conduct. And while it is almost impossible to comprehend what his children must now endure, my heart goes out to them also, because they must live with the terrible realization of who their father truly was and is. On that day, defendant was not a father. He was not a protector. He was and continues to be a manipulative, cold-blooded killer who destroyed every life around him in a ruthless effort to preserve his own. With that backdrop, the court will consider the aggravating and mitigating sentencing factors. As I pointed out, the defense requests that the court take into consideration the 9 letters from defendant's family and close friends, as well as any appropriate mitigating factors, and I will do so. The state submits that there is no applicable mitigating factors and argues that aggravating factors 2C44-1A1, 1A2, 1A3, and 1A9 should apply. In determining a sentence, the court must consider the nature of the offense and the relevant aggravating and mitigating factors. State v. Zuber, 227 NJ 422 450 2017. The court is required to consider all the aggravating and mitigating factors to find those supported by the evidence. That's State v. Dalziel, 182 NJ 494 505 2005. The court's personal views in rectifying social ills cannot be a factor in determining punishment. State v. Eichert, 369 NJ Super, 610, 621, Appellate Division 2004. Sentencing decisions follow a qualitative rather than a quantitative analysis. State v. LV, 410 NJ Super, 90, 108, Appellate Division 2009. Certif denied, 201, New Jersey, 156, 2010. The factors are not simply balanced and afforded equivalent value. The court must focus upon the offense when formulating a sentence. State v. Roth, 95, New Jersey, 334, 368, 1984. State v. Hodge, 95, New Jersey, 369, 377 through 379, 1984. And State v. McFarland, 224, New Jersey, 458, 466, 2016. And lastly, State v. Fuentes, 217, New Jersey, 57, 72, and 73, 2014. Thus, the statute requires a thoughtful weighing of the aggravating and mitigating factors, not merely counting one against the other. State v. Denman, 347 NJ Super, 457, 467, 68, Appellate Division, Certif denied, 174, New Jersey, 41, 2002. An explicit statement on the record of the aggravating and mitigating factors found and how they were balanced is required. That's State v. Natali, 184, New Jersey, 458, 489, 2005. The court has far-ranging discretion as to the source and types of evidence used in determining the punishment imposed. State v. Davis, 96, New Jersey, 611, 619, 620, 1984. NJSA 2C44-1A sets forth 15 aggravating factors a court shall consider when imposing a sentence. Where the legislature has already taken certain aspects of the nature and circumstances of the offense into account in grading, the court may not consider those same aspects against the aggravating factors. State v. Pineda, 119, New Jersey, 621, 1990. Thus, a victim's death generally may not be viewed as an aggravating factor in a homicide. State v. Carey, 168, New Jersey, 413, 425, 2001. However, the nature of the death can be considered in sentencing for homicide. State v. Soto, 340, NJ Super, 47, Appellate Division, Certif denied, 170, New Jersey, 209, 2001. The court finds aggravating factor number 1, the nature and circumstances of the offense and the role of the actor therein, including whether or not it was committed in an especially heinous, cruel, and depraved manner. This factor has been held to include The cruel manner of the attack, State v. Roth, 95 New Jersey at 367. The brutal and senseless nature of the stabbing, State v. Bowens at 639. And the painful, dreadful killing of a child by fire, State v. Lewis, 223, NJ Super, 145, 153, Appellate Division, certif denied, 111, New Jersey, 584, 1988. In this case, this factor is applicable and is entitled to significant weight. Under this factor, the sentencing court reviews the severity of the defendant's crime, the single most important factor in the sentencing process, assessing the degree to which the defendant's conduct threatened the safety of the direct victims and the public. State v. Lawless, 214, NJ 594, 609, 610, 2013. In doing so, the court focuses on the gravity of the defendant's conduct, considering both the impact upon the immediate victims and the overall circumstances surrounding the criminal event. It is 609. When assessing whether a defendant's conduct was especially heinous, cruel, or depraved, a sentencing court must avoid double-counting facts that establish the elements of the irrelevant offense. State v. Fuentes, 217, New Jersey at 74 and 75. To demonstrate this factor, a sentencing court may consider whether the aggravating facts show that a defendant's behavior extended to the extreme reaches of the prohibited behavior. It at 75. In State v. Rivers, the Appellate Division found a factual basis for an especially heinous, cruel, and depraved manner of an offense where the defendant intentionally shot unarmed victims and pointed his gun at others. 252 NJ Super, 142, 152 to 154, Appellate Division 1991. The facts in this case establish conduct that falls squarely within the most extreme reaches of brutality contemplated under aggravating factor number 1. Defendant did not merely kill his victims. He subjected them to prolonged, savage, and excessive violence that went far beyond what was necessary to cause death. The sheer number and nature of the injuries inflicted upon each victim demonstrate calculated cruelty, domination, and a complete disregard of human suffering. Defendant intentionally shot Keith Caneiro multiple times. The attack culminated in an execution-style gunshot wound to Keith's head. That final shot was not necessary to accomplish the killing. It reflected deliberate and methodical violence inflicted upon a defenseless victim laying on the ground with his face in dirt. The multiple gunshot wounds culminating in the fatal shot to the head demonstrated an unmistakable intent to annihilate rather than to simply kill. The manner of the attack revealed coldness, brutality, and a complete indifference to human life. Defendant then turned to Jennifer Caneiro. He shot Jennifer in the head, and while she remained alive, repeatedly stabbed her. The evidence established defendant inflicted multiple stab wounds after already delivering a catastrophic gunshot wound. Those additional wounds dramatically increased Jennifer's suffering and terror. The attacks were not instantaneous. Defendant prolonged the violence and inflicted repeated, penetrating injuries upon a woman already gravely injured. The repeated stabbing after the gunshot wound reflected rage, overkill, and extraordinary cruelty well beyond that was required to cause death. The violence inflicted upon Jesse and Sophia were even more horrifying in its cruelty and depravity. The evidence presented at trial established that these children desperately tried to flee from inside their home while the defendant hunted them with a knife. The crime scene reflected terror, panic, desperate attempts to escape, and attempt to protect their own lives. These children experienced imaginable fear in the final moments of their lives as their uncle relentlessly pursued and attacked them. Defendant repeatedly stabbed Jesse. The wounds were not isolated or incidental. They reflected a sustained and violent assault. Jesse suffered defensive injuries establishing that he consciously attempted to protect himself from the defendant's attacks. Those injuries demonstrate that Jesse experienced the terror of fighting for his life while defendant continued the assault. Defendant nevertheless persisted, repeatedly driving the knife into a child attempting to survive. The brutality of repeatedly stabbing a child who is actively trying to defend himself demonstrates conduct that was especially cruel and depraved. The injuries inflicted upon Sophia were particularly shocking in both their savagery and force. Defendant stabbed Sophia through her nasal cavity with such violence that it fractured her sinus and penetrated her brain. Another stab wound pierced her chest cavity and collapsed her lung. That's what you did. These were catastrophic injuries inflicted with overwhelming force. The natures of the wounds demonstrated repeated acts of extreme violence directed at one of the most vulnerable victims imaginable. Defendant did not stop after inflicting lethal injuries, though. He continued the assault with a level of force and brutality that far exceeded that would have been necessary to cause death. Even after inflicting those devastating injuries, defendant abandoned Sophia inside the burning home. Rather than summon help or rescue, defendant left her lying helpless. Defendant left her lying helpless as smoke and fire consumed the residence over the course of hours. Sophia was left for dead with no ability to move. The medical evidence confirmed that smoke inhalation contributed to her death. Sophia's blood contained an extraordinary 49% carboxyhemoglobin level, demonstrating that she remained alive and continued breathing toxic smoke after suffering multiple catastrophic stab wounds. The suffering associated with those final moments of life is almost impossible to comprehend. Sophia endured devastating injuries while simultaneously inhaling poisonous smoke as the fire spread through the home around her. The image presented by the evidence is one of extraordinary cruelty. An injured child, mortally wounded and unable to escape, struggling to breathe while trapped inside a burning home after being brutally attacked by the defendant. The home, which should have represented safety and protection, instead became the setting for the prolonged terror, agony, and her death. As recognized in State v. Lewis, the painful and dreadful killing of a child by fire constitutes precisely the type of especially heinous and depraved conduct contemplated by aggravating factor number 1. The fact that the defendant inflicted injuries far beyond those minimally necessary to accomplish the murders strongly supports this factor. The fact that this defendant did more than was minimally required to satisfy an element of the offense may properly be considered under aggravating factor 1, even where the conduct overlaps with the elements of the crime. That's C. Caneiro, New Jersey Code Annotated, Comment 3, NJSA 2C44-1A, also citing State v. Mara. In State v. Mara, the Appellate Division upheld a finding of aggravating factor 1 where the harm inflicted exceeded the single serious injury necessary to establish aggravated assault. 253 NJ Super, 557, 567 Appellate Division, 1996. Similarly, in State v. Fuentes, the Supreme Court discussed repeated stabbing, continued beating, and the use of excess force as conduct potentially supporting aggravating factor 1 when properly explaining it by the sentencing court. That's 217 New Jersey at 77. Here, the court has carefully evaluated all the injuries inflicted by each and every victim, both individually and collectively, the multiple gunshots to Keith, including the execution-style shot to the head, the gunshot wound to Jennifer's head, followed by multiple stab wounds when she remained alive, the repeated stabbing of Jesse as he attempted to defend himself, the catastrophic stab wounds inflicted upon Sophia and her defensive wounds, and the additional suffering caused by smoke inhalation, and the fire demonstrated violence that extended far beyond what was necessary for the murder themselves. These acts were not merely intentional killings, they were executions carried out in an especially heinous, cruel, and depraved manner. The court therefore finds aggravating factor 1 fully applicable and affords it significant weight. The court also finds aggravating factor number 2. The gravity and seriousness of the harm inflicted on the victim, including whether or not the defendant knew or reasonably should have known that the victim of the offense was particularly vulnerable, or was for any other reason substantially incapable of exercising normal physical or mental power of resistance. Sentencing judges are instructed by the Supreme Court to examine the totality of the harm inflicted. State versus Kromhold, 162 NJ, 345, 358, 2000. In applying that case, the court focuses on Sophia's and Jesse's extraordinary vulnerability and their substantial inability to exercise any meaningful physical resistance during defendant's brutal attack. The evidence established that the defendant completely outpowered both children through his sheer size, strength, and possession of deadly weapons. Sophia stood only 4 feet tall and weighed approximately 45 pounds. Her stature was exceptionally small and thin. Jesse measured 4 feet 10 inches tall and weighed only 95 pounds. Defendant, by contrast, weighed approximately 230 pounds, stood 5 feet 11 inches tall at the time of his arrest. Defendant outweighed Sophia by approximately 185 pounds and outweighed Jesse by approximately 135 pounds. He towered nearly 2 feet over Sophia and a foot over Jesse. The disparity in size, weight, strength, and physical power between defendant and these children is staggering. Sophia and Jesse were innocent, defenseless, and obviously unarmed children. Defendant was a full-grown adult male armed with a knife. These children had absolutely no realistic ability to defend themselves, escape, or resist defendant's violent assault. State versus Pineda, 119 NJ 621, 628, 1990. The gravity and seriousness of the harm inflicted upon Sophia and Jesse cannot be overstated. Defendant exploited their complete physical vulnerability and used overwhelming force against children who were utterly incapable of protecting themselves from the terror and violence he unleashed. The attacks were not momentary or accidental. Defendant used a knife against 2 small children who faced a terrifying and hopeless situation against a much larger armed adult. Their vulnerability magnified the cruelty of the offense and the severity of the suffering inflicted upon them. Defendant's conduct also demonstrated profound cowardice. Rather than confront an equal, defendant chose to attack 2 exceptionally vulnerable children who posed no threat to him whatsoever. He used that overwhelming size, weight, strength, and possession of a deadly weapon to dominate and to terrorize children who were physically incapable of defending themselves. Sophia and Jesse were powerless against defendant's assault. Defendant preyed upon that helplessness and exploited it in the most brutal way imaginable. The court finds that the overwhelming imbalance of physical power combined with defendant's use of a deadly weapon against 2 defenseless children demonstrates an extreme level of brutality, cowardice, and helplessness that strongly supports this aggravating factor, and I give it significant weight. The court also finds aggravating factor number 3, the risk the defendant will commit another offense. When the sentencing court relies upon the risk of another offense, the court must identify particular facts supporting that finding. State versus Case, 220 NJ 49, 66, 67, 2014. The court does so here. In State v. Verona, the Appellate Division upheld a finding that the defendant presented a risk of committing another offense, even though he had no prior criminal record. 242 NJ Super 474, 491, 492, Appellate Division, Certif denied 122, New Jersey, 386, 1990. There, the defendant was an established businessman in a community. Yet, the discovery of a kilogram of cocaine in his possession demonstrated access to large quantities of narcotics and supported the conclusion that he would likely engage in future criminal conduct if permitted to remain free. It at 491. The Appellate Division nevertheless noted that the sentencing court in Verona afforded this factor only some weight. Similar to the defendant in Verona, defendant here has no prior criminal convictions. Unlike Verona, however, the facts supporting the risk of reoffense are significantly stronger, more disturbing, and far more compelling. The court does not base this finding upon speculation or generalized concerns. The court bases the finding upon the extraordinary level of planning, calculation, concealment, and sustained criminal conduct reflected throughout this case. These offenses were not spontaneous or impulsive acts committed in a moment of uncontrolled rage. Defendant engaged in a deliberate and methodical course of conduct that involved multiple weapons, multiple victims, and calculated efforts to destroy evidence and evade responsibility. Defendant armed himself and carried out separate acts of violence against 4 separate victims. After inflicting those catastrophic injuries, defendant set multiple fires through 2 different homes at 2 different locations, miles apart from each other, in an effort to conceal the murders and destroy evidence. The use of different weapons, the sequential nature of the attacks, and the deliberate acts of setting fires afterwards demonstrated organized, purposeful, and calculated criminal behavior. Defendant did not stop after the killings. The court finds that those facts critically important in assessing future dangerousness. They reveal a defendant capable of calculated violence followed by deliberate attempts to cover up his crimes. The sheer scope and complexity of defendant's actions strongly support the conclusion that he presents a continuing risk to society. Defendant demonstrated a willingness to commit extreme violence when it served his personal interests. He further demonstrated a willingness to engage in additional criminal conduct afterwards in order to conceal what he had done. The murders themselves are horrific. The calculated attempts to erase evidence through fire magnified the danger defendant presents, the danger defendant presents because they reflect planning, consciousness of guilt, and continued willingness to break the law to avoid accountability. Moreover, the jury here convicted defendant of theft-related offenses spanning over 2 years. Those convictions established that defendant engaged in an ongoing pattern of unlawful conduct long before the murders. State v. Locane, 454, NJ Super, 98, 121, Appellate Division, 2018. This was not an isolated lapse of judgment by an otherwise law-abiding citizen. The evidence demonstrated sustained, dishonest, and criminal behavior over an extended period of time. The murders themselves directly flowed from defendant's efforts to conceal and protect those ongoing illegal acts. Defendant's willingness to escalate from long-term theft and deception to calculated murder and arson demonstrates an alarming progression of criminal conduct. The court also finds defendant's complete lack of remorse highly significant. In State v. Rivers, the Appellate Division held that a defendant's lack of remorse properly supported aggravating factors 3 and 9. 252 NJ Super 142 153 Appellate Division 1991. Here, defendant has shown absolutely zero remorse for the murders of Keith, Jennifer, Jesse, and Sophia, and for burning down his own family's home. despite the avalanche of evidence. Defendant has failed to acknowledge the overwhelming and devastating evidence establishing his guilt. He has shown no compassion for the victims, no acceptance of responsibility, and no recognition of the suffering he inflicted upon the entire family, his own, and everybody else in this room. That absence of remorse matters because it demonstrates to this court that the defendant has not confronted the magnitude of his crimes or accepted responsibility for his conduct. A defendant who refuses to acknowledge overwhelming evidence even after conviction presents a greater risk of future criminal behavior because there is no indication of rehabilitation, insight, or moral reckoning. Instead, defendant's conduct reflects continued self-preservation and a denial in the face of catastrophic violence. The court therefore finds, based upon the particular facts in this case, that the defendant presents a substantial risk of committing another offense if given the opportunity. The prolonged theft-related conduct, the calculated and gruesome murders, the use of multiple weapons, the deliberate setting of fires to conceal the crimes, and defendant's complete absence of remorse collectively establishes aggravating factor number 3. The court affords this factor significant weight. The court looked at aggravating factor 4, 5, 6, 7, and 8 and find all of them to be inapplicable. Aggravating factor number 9, the need to deter this defendant and others from violating the law. This factor is applicable and also afforded significant weight. The court's determination under aggravating factor 9 requires a qualitative and net assessment of the risk of recidivism and also involves determinations that go beyond the simple finding of a criminal history and includes an evaluation and judgment about the individual in light of his or her history. State v. Thomas, 188, NJ 137, 153, 2006. Deterrence has been repeatedly identified in all facets of the criminal justice system as one of the most important factors in sentencing and is the key to proper understanding of protecting the public. State v. McGargle, 143, NJ 484, 501, 1996, citing State in the Interests of CAH and BAR, 89, New Jersey, 326, 334, 1982. Moreover, demands for deterrence are strengthened in direct proportion to the gravity and harmfulness of the offense. CAH 89, New Jersey at 337. For purpose of aggravating factor 9, deterrence incorporates two interrelated but distinguishable concepts, namely the sentence's general deterrent effect on the public and its personal deterrent effect on the defendant. State v. Jarbuth, 114, New Jersey, 494, 405, 1989. Cases where imprisonment for serious crimes will not further the goal of general deterrence are extremely rare, it at 408. At the same time, in the absence of a finding supporting specific deterrence, general deterrence has relatively insignificant penal value, it at 405. Accordingly, the sentencing court focuses on the need to deter the individual defendant from violating the law. The evidence in this case established defendant's conduct was calculated, organized, and purposeful criminal conduct extending over a significant period of time. As I mentioned, he engaged in the theft-related offenses over the course of nearly 2 years. Those ongoing criminal acts ultimately culminated in 4 murders, 2 arsons, weapons offenses, and hindering apprehension. The evidence demonstrated that the defendant committed these crimes to protect his own interest and ongoing illegal conduct. The nature of the crimes themselves powerfully supports both general and specific deterrence. Defendant murdered 4 people, including 2 children, through calculated and extraordinary violence. He used multiple weapons. He repeatedly shot and stabbed victims far beyond what was necessary to cause death. He then set fires throughout the home in an effort to destroy evidence and conceal the murders. These were not crimes committed in panic or confusion. The defendant made a series of deliberate choices before, during, and after the murders. Every stage of the criminal episode reflected conscious decision-making and calculating conduct. The need for general deterrence in this matter is overwhelming. Society must receive a clear and unmistakable message that calculated murder, the slaughter of children, and the use of arson to conceal crimes will result in the most serious punishment permitted by law. Crimes of this magnitude strike at the very foundation of public safety and civilized order. The brutal murder of an entire family inside their home creates fear far beyond the direct victims because it destroys the sense of security that every person should feel within their own residence. The law must respond forcefully to conduct of this nature in order to deter others who might contemplate resolving financial pressure, exposure, or personal problems through calculated violence. The court also finds an extraordinary need for specific deterrence. Defendant presents a substantial risk of reoffending for the reasons I've already stated. Defendant demonstrated a willingness to engage in sustained criminal conduct, escalate the conduct into calculated murder, and then commit additional crimes to conceal his actions. Those facts establish a profound disregard for human life, for our societal laws, and it is clear to me that he does not see that. Moreover, unlike the defendant in Jarbuth, defendant fully understood the nature and consequences of his actions. The evidence established planning, concealment, destruction of evidence, and efforts to avoid detection. Those acts demonstrate consciousness of guilt and awareness that his conduct was criminal. Despite the overwhelming evidence presented during approximately 5 weeks of testimony, defendant has shown absolutely zero remorse, no empathy, no acceptance of responsibility. While defendant maintains the constitutional right to remain silent and he asserts his innocence here, the court may nevertheless consider the complete absence of remorse in evaluating the need for deterrence. Defendant displayed no credible emotion or acknowledgement of the devastation he caused to 4 victims and an entire extended family. Defendant's own desires, decisions, and self-interest drove every stage of these crimes. The evidence demonstrates calculated choices, not diminished capacity or misunderstanding. Accordingly, the court finds a strong basis supporting both general and specific deterrence. For all of those reasons, the court finds aggravating factor number 9 fully applicable and affords it significant weight. The court has looked at the remaining aggravating factors and finds all of them inapplicable. The court will now balance the mitigating factors. In determining the appropriate sentence to be imposed on a person who has been convicted of an offense or offenses, the court must properly consider the following mitigating circumstances pursuant to NJSA 2C 44-1B. Number 1, the defendant's conduct neither caused nor threatened serious harm. Here, the defendant shot and stabbed 4 people to death while also putting his own family at risk of death. As such, defendant's conduct did in fact cause serious harm. Mitigating factor 1 is inapplicable. Number 2, the defendant did not contemplate that his conduct would cause or threaten serious harm. Defendant planned the murders in the hours leading up to leaving his house and when he left in his car in darkness to kill his family. He armed himself with a gun and knife and committed these crimes. He used a flammable liquid or gasoline to burn 2 homes. Mitigating factor 2 is inapplicable. Number 3, the defendant acted under strong provocation. There is no evidence defendant acted under any provocation. Factor 3 is inapplicable. There were substantial grounds tending to excuse or justify defendant's conduct through failing to establish a defense. That's mitigating 4. There is absolutely no excuse for defendant's heartless, brutal behavior. Mitigating factor 4 is inapplicable. Number 5, the victim of the defendant's conduct induced or facilitated its commission. There was no evidence that defendant's conduct was induced by any victim. All victims in this matter were defenseless. Mitigating factor 5 is inapplicable. Defendant has compensated or will compensate the victim of his conduct for the damage or injury that he sustained, or he will participate in a program of community service. Defendant can't compensate anybody in this case because he killed everybody in this case. Mitigating factor 6 is also inapplicable. Number 7, defendant has no prior history of delinquency or criminal activity, or has led a law-abiding life for a substantial period of time before the commission of the present offense. As I've mentioned, defendant has no prior criminal convictions, therefore the court will give this factor some weight. Number 8, the defendant's conduct was the result of circumstances unlikely to reoccur. Mitigating factors 8 and 9 are to be weighed against aggravating factor number 3, State versus Towie, the second, 244 NJ Super, 582, 593, 594, Appellate Division 1990. Since the court has afforded significant weight to aggravating factor number 3, mitigating factor 8 is also inapplicable. Number 9, the character and attitude of the defendant indicated that he is unlikely to commit another offense. Again, since mitigating factors 8 and 9 are to be weighed against aggravating factor 3, mitigating factor number 9 is inapplicable. I'm citing Towie at 593 and 94. Also, defendants are likely to get the benefit of mitigating factor number 9 when they show remorse, which is Rivera 249 NJ at 293 and 294. But a lack of remorse is sufficient to preclude this application. State versus O'Donnell, 117 New Jersey, 210, 216, 217, 1989. In this case, defendant has shown no remorse. Mitigating factor 9 is inapplicable. Defendant is particularly likely to respond affirmatively to a probationary treatment. Mitigating factor 10 is inapplicable because defendant has been convicted of a crime with a presumption of incarceration. State versus Scene, 443, NJ Super, 134, 144 to 145, Appellate Division 2015. Mitigating factor number 11, the imprisonment of the defendant would entail excessive hardship to the defendant or the defendant's dependents. Defendant has 2 adult children who do not rely on defendant for financial support. While it is always hard to lose a parent when there is a presumption of incarceration, there is nothing in the record to support this mitigating factor. Therefore, mitigating factor 11 is inapplicable. Mitigating factor number 12, the willingness of the defendant to cooperate with law enforcement. Defendant actively hindered the investigation, attempted to destroy critical evidence by setting fires to both residents connected to these offenses. Those deliberate acts of arson were calculated efforts to conceal murders, eliminate forensic evidence, and to obstruct investigators from uncovering the truth. Mitigating factor 12 is inapplicable. Mitigating factor 13, the conduct of a youthful defendant was substantially influenced by another person more mature than the defendant. That factor is inapplicable. Defendant was not under the age of 26. Mitigating factor 14 is inapplicable. And mitigating factor 15 only applies for offenses other than murder. He was charged with murder here, therefore it's inapplicable. Therefore, the court finds aggravating factors 1, 2, 3, and 9 giving each significant weight, and found only one mitigating factor, number 7, which the court gave some weight. The aggravating factors clearly and substantially outweigh the mitigating factors here. Now, before I impose sentence, I will also consider the doctrine of merger of some of these crimes for which the defendant was found guilty. The doctrine of merger, codified in NJSA 2C1-8A, governs whether multiple convictions arising from the same conduct may stand separately for sentencing purposes. The statute provides that although a defendant may be prosecuted for more than one offense arising from the same conduct, the defendant may not be convicted of more than one offense where, 1, one offense is included in the other, 2, one offense consists only of conspiracy or preparation to commit the other, 3, inconsistent findings of fact are required to establish the offenses, or 4, the offenses differ only in that one prohibits conduct generally and the other prohibits a specific instance of that conduct. A determination regarding merger must be made by the court after a verdict or finding of guilt. 2C1-8A. The doctrine of merger rests upon the principles that a defendant who commits a single offense may not be punished as though he committed multiple offenses for the same conduct. State versus Tate, 216, New Jersey, 300,302, 2013. Quoting State versus Davis, 68, New Jersey, 69, 77, 1975. Convictions for lesser included offenses that are a necessary component of the commission of another offense, or offenses that merely offer an alternative basis for punishing the same criminal conduct, will merge. State versus Brown, 138, New Jersey, 481, 561, 1994. In determining merger, the court also applies the flexible analysis articulated in Davis, which examines the time and place of each offense, whether proof of one offense is necessary to prove the other, whether one act formed part of a larger scheme, the defendant's intent, and the consequences of the criminal standards violated. That's Davis, 68, New Jersey at 81. The court finds that count 5 merges into count 3 and count 6 merges into count 4. Count 3 charges the defendant with murder of Jesse Caneiro. Count 5 charges felony murder of Jesse Caneiro during the commission of an arson at 15 Willowbrook Road. Count 4 charges the murder of Sophia Caneiro, and count 6 charges felony murder of Sophia Caneiro during the same arson. These offenses constitute alternative theories of liability for the same homicides. See State versus Brown, 138, New Jersey, 561. The offenses occurred during the same criminal episode, at the same location, and within a short period of time. Proof of the murders was necessary to sustain the felony murder convictions. Further, the felony murder counts form part of the larger scheme in which defendants set the resident on fire to ensure Jesse and Sophia would not survive. Because the offenses are substantially identical in both fact and law, separate convictions would violate the principles set forth in Davis. Accordingly, count 5 merges into count 3 and count 6 merges into count 4. The court finds that count 7, aggravated arson at 15 Willowbrook Road, does not merge. Once the felony murder counts merges into the murder counts, aggravated arson remains a distinct offense because proof of arson was not necessary to establish the murder convictions. Again, that's Brown, 138, New Jersey at 561. Count 8, aggravated arson at 27 Tilton Drive, defendant's own residence, also does not merge because it involved a separate criminal act committed at a separate location. The court finds that count 9, possession of a handgun for unlawful purpose, merges into counts 1 through 4. The jury instructions identified the unlawful purpose as defendant's use of a handgun against Keith Caneiro, Jesse Caneiro, Jennifer Caneiro, and Sophia Caneiro. The evidence did not establish any broader unlawful purpose beyond the murders themselves. Unlike State versus Diaz, when the only unlawful purpose in possessing the gun is to use it to commit the substantive offense, merger is required. That's 144 New Jersey at 636. Unlike State versus Tate, clarified that a weapon possession conviction merges when the evidence does not support another unlawful purpose for possessing the weapon. That's 216 New Jersey at 303. Because the state provided no broader unlawful purpose here, count 9 merges into counts 1 through 4. The court finds that count 11, possession of a knife for unlawful purpose, merges into counts 2 through 4. The jury was instructed the defendant possessed the knife for the purpose to use it unlawfully against Jennifer Caneiro, Jesse Caneiro, and Sophia Caneiro. The evidence established no broader unlawful purpose beyond the commission of those murders. Accordingly, merger is required under Diaz and Tate. The court further finds that count 12, unlawful possession of a knife, merges into count 11 pursuant to NJSA 2C1-8A1 because the elements of count 12 were subsumed within count 11. Counts 13, 14, 15, and 16. The court finds that count 13, theft of movable property, and count 14, misapplication of entrusted property, do not merge. These offenses involve separate conduct occurring over different periods of time and constituted distinct criminal acts from the homicide-related offenses. The court further finds that counts 15 and 16, hindering apprehension of oneself, do not merge into any other counts. Those offenses occurred at different locations and involved separate conduct from the murders, arsons, and theft-related offenses. Additionally, the elements of hindering differ materially from the remaining offenses. So therefore, the court finds as follows. Count 5 merges into count 3. Count 6 merges into count 4. Count 9 merges into counts 1 through 4. Count 12 merges into count 11. And count 11 merges into count 2 through 4. The defendant will be sentenced as to count 1, 2, 3, 4, 7, 8, 13 through 16. The next analysis is whether the court will consider consecutive versus concurrent sentencing. NJSA 2C44-5A authorizes the court to impose multiple sentences either concurrently or consecutively with no outer limit on cumulation. Before making the determination, the court must sentence each offense individually, accounting aggravating and mitigating factors under NJSA 2C44-1A and 1B, and citing State v. Rogers, 124 NJ 113, 119, 1991. State v. Yarborough, 100 New Jersey, 627, 643, 644, 1985, establishes 6 guidelines. There can be no, number 1, there can be no free crimes. Punishment must fit the crime. 2, the court must separately state its reasons for imposing consecutive or concurrent sentences. Number 3, the court must consider facts relating to the crimes, including whether A, the crimes and their objectives were predominantly independent of each other, B, the crimes involved separate acts of violence or threats of violence, C, the crimes were committed at different times or places rather than so close in time and place as to indicate a single period of aberrant behavior, D, any of the crimes involved multiple victims, and E, the convictions were numerous. 4, there shall be no double counting of aggravating factors. 5, successive terms for the same offense should not ordinarily equal the punishment for the first offense. 6, cumulative consecutive sentences should not exceed the sum of the longest terms imposable for the 2 most serious offenses. State v. Carey, 168 New Jersey, 413, 423, 2001, reaffirmed the guidelines 2, 4, 5, and 6 address procedural requirements only. Guideline 1 tilts towards consecutive sentences because it focuses on the crime, not on the criminal. Guideline 3 is therefore the substantive deciding factor and must be weighed qualitatively and not quantitatively, it at 427. The court may impose consecutive sentences even when a majority of the Guideline 3 factors favor concurrent sentences. Crimes involving multiple deaths or serious bodily injuries are especially appropriate for consecutive sentences. That's Carey at 428. As to count 1, 2, 3, and 4, the 4 murders charged in this case, all Guideline 3 factors support consecutive sentences. Factor A, B, and C, the 4 murders were independent of each other. Each involved a separate act of violence by different means and in different locations. Defendant shot Keith Caneiro on the lawn, stabbed and shot Jennifer Caneiro inside the home, stabbed Jesse Caneiro with potential gunshot and smoke inhalation, and stabbed Sophia Caneiro and caused her death through smoke inhalation from a fire he set. Although the killing occurred within a compressed time frame, they were sufficiently distinct as not to constitute a single period of aberrant behavior. Factor D, there were 4 separate victims. Factor E, with 15 total convictions and 10 sentences to be imposed, the conviction count is numerous. Carey, 168 New Jersey at 424. Consecutive sentences are warranted when balancing the guidelines on all 4 of these counts for the murders, and that's Carey at 428. As to counts 7 and 8, the aggravated arsons, Count 7, the arson at 15 Willowbrook Road, runs concurrently. Factor A through D favor concurrent sentencing. The fire was sent contemporaneously with the murders, was closely intertwined with the course of conduct, and contributed to the two victims' causes of death. It did not constitute an independent criminal episode. Therefore, it will run concurrent. Count 8, the arson at 27 Tilton Drive, will run consecutively. That arson was independent under factors A through C. It occurred at separate locations after a break in the chain of events of driving from one crime scene to another. Factor D further supports consecutive sentences because it introduced 3 new victims, Caitlin, Marissa, and Susan Caneiro. Although Factor E favors concurrent sentencing, given the accumulating number of consecutive sentences, the separate location and new victims render this conduct a distinct criminal episode. Therefore, the guideline warrants a consecutive sentence. Count 13, theft. Count 13, theft, will run consecutively. The theft occurred in 2017 and 2018, well before the November 2018 murders, and constituted repeated, independent criminal conduct. Factors A, B, C favor consecutive sentencing. The theft's objectives were independent of the homicide and arson offenses, involved no acts of violence, and were so temporally removed as to not reflect a single period of aberrant behavior. Factor D marginally favors concurrent sentencing because the theft victims overlap the murder victims. Factor E also favors concurrent sentencing given the number of consecutive sentences already imposed. Nonetheless, there can be no free crimes, Guideline 1, carry 168 NJ at 423, and the court may impose consecutive sentences even where a majority of factors favors otherwise, it at 427. 3 factors here favor consecutive sentences, and the theft is substantially distinct from the homicide and arson offenses. Therefore, a consecutive sentence is appropriate. Count 14, misapplication of entrusted property. That will run concurrent. It arises from the identical conduct from Count 13, misappropriation of funds from Keith Caneiro's trust at the same time in the same location with the same victims. All Guideline 3 factors favor concurrent sentencing, and running it consecutively would impose multiple punishments for a single criminal act. Counts 15 and 16, the hindering. Count 15 related to hindering apprehension related to the murders. Count 15 will run concurrently. Defendant attempted to destroy bloody soaked clothing after the murders by setting it on fire. Factor A, the offense was not independent of the murders. Factor B, the conduct was identical to the arson. Factor C, it occurred contemporaneously with and at the same location as the arson. Factor D, the victims were the same as the murder victims. Factor E, a consecutive sentence would push the total towards the numerous range. A majority of these factors favor concurrent sentencing. Factor 16, hindering apprehension related to the theft of misapplication. The theft of misapplication of entrusted property will also run concurrently. Defendant committed these offenses in furtherance of counts 13 and 14 by forging documents and stealing from Keith Caneiro's trust. All Guideline 3 factors favor concurrent sentencing. Factors A, B, and C. The offense was not independent, and it was committed in furtherance of the same course of conduct. Factor D, the victims were the same. Factor E, a consecutive sentence would further approach the numerous range. With that said, the court finds as following. Count 2 runs consecutively to count 1. Count 3 runs consecutively to count 1 and 2. Count 4 runs consecutively to counts 1 through 3. Count 8 runs consecutively to the aggregate of counts 1 through 4. Count 13 runs consecutively to the aggregate of counts 1 through 4 and 8. Count 7, 14, 15, and 16 run concurrently with the aggregate consecutive sentences. So with that being said, the court will impose the following sentence. Under indictment 19-02-0283, count 1, charging you with murder in violation of 2C11-3. I sentence you to the custody of the Commissioner of the Department of Corrections to life with no possibility of parole. This was a Graves Act offense. There's a $100 VCCO penalty, a $75 safe neighborhood assessment penalty, and a $30 law enforcement trading fund penalty. You have 2,745 days of jail credit. As to count 2, charging murder in violation of 2C11-3, a first-degree offense, I sentence you to the custody of the Commissioner of the Department of Corrections for life without the possibility of parole. Again, to run consecutive to count 1. This is also a Graves Act offense. There's a $100 VCCO, $75 safe neighborhood assessment penalty, and again, the same jail credit. Count 3, charging you with murder in violation of 2C11-3, a first-degree offense. I sentence you to the custody of the Commissioner of the Department of Corrections for life with no possibility of parole. There's a $100 VCCO penalty and a $75 safe neighborhood assessment penalty. Count 4, charging you with murder in violation of 2C11-3. I sentence you to the custody of the Commissioner of Department of Corrections for life without the possibility of parole. That's a $100 VCCO penalty and a $75 safe neighborhood assessment penalty. Again, each one of those are consecutive to each other. As to count 7, aggravated arson in violation of 2C17-1A, a second-degree offense, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 18 years, subject to the No Early Release Act, which means that you must serve 85% of that 18-year sentence. There's also on that offense, because it's a nearer offense, even though it's inapplicable, you would have a 3-year parole supervision if you were released, but that will never happen in this case. There's a $100 VCCO penalty, a $75 safe neighborhood assessment penalty, and again, the same jail credit. The reason why for the $100 VCCO there is because that is for the Colts Neck residents. Count 8, aggravated arson in violation of 2C17-1A, a second-degree offense. I sentence you to custody of the Commissioner of the Department of Corrections for a period of 18 years, subject to the No Early Release Act, meaning that you have to serve 85% of 18 years before you be eligible for parole. That is run consecutive to the 4 life terms that I just gave you. There's a $50 VCCO and a $75 safe neighborhood assessment penalty. Again, the same jail credit. As to count 13, theft in violation of 2C20-3, a second-degree crime, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 18 years. There's a $50 VCCO and a $75 safe neighborhood assessment penalty. Again, so that will run consecutive to the 18 years I gave you on the arson and also the 4 life terms that I've given you. As to count 14, misapplication of entrusted property in violation of 2C21-15, a second-degree crime, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 18 years. There's a $50 VCCO, a $75 safe neighborhood assessment penalty, and that will run concurrent to count 13. Count 15, hindering your own apprehension for the murders in this case, in violation of 2C29-3B1, a third-degree offense. I sentence you to custody of the Commissioner of the Department of Corrections for a period of 4 years. There's a $50 VCCO, $75 safe neighborhood assessment penalty. Again, that will run concurrent with the same jail credit. Count 16, hindering apprehension, dealing with the theft and the misapplication of entrusted property. In violation of 2C29-3B1, a third-degree offense, I sentence you to the custody of the Commissioner of the Department of Corrections for a period of 4 years. There's a $50 VCCO, a $75 safe neighborhood assessment penalty. Again, that is to run concurrent on all counts. Today, defendant's greed, manipulation, and selfish conduct ends. His address will forever be the Department of Corrections. His only reality is confinement, consequence, and accountability. Punishment is paramount, and the court imposes it without any hesitation. While defendant will not acknowledge his behavior and wrongdoing, a jury of his peers did. And this court now imposes a sentence that fully reflects the verdict and the gravity of these offenses. Although more than 7 years passed before this matter reached trial due to COVID, pretrial litigation, and the complexity of these proceedings, justice delayed is not justice denied. You are no longer Paul Caneiro. You are an intimate number in the Department of Corrections. You are a quadruple murderer who slaughtered innocent children. That is your identity. That is the identity you will carry for the remainder of your life behind prison walls, confined to a 4-foot by 7-foot cell until your final breath. That's the sentence I'm imposing. You have 45 days from today's date to file an appeal of this sentence. If you miss the 45-day deadline, you can get a 30-day good cause extension if you can show good cause. If you cannot show good cause, you can be losing your right to an appeal. You also have 5 years from today's date to file a post-conviction relief. I have the appeals right form that has been signed by the defendant and by Ms. Mastalone. Prosecutor, anything else?
Judge, can you speak for yourself?
You can. Do you have anything to add?
Sentence that was just imposed, the statement was dismissed indictment 1907-1038.
That will be dismissed. All right. Thank you all.
Thank you.